Welcome to Moneylife Foundation program, Mr. Thakur, and all assembled guests. Mr. Thakur is a chartered accountant, somewhat different from the other run-of-the-mill chartered accountant because he speaks his mind and he's chosen an area of practice where he can do so. But he runs his own firm, Jayant Thakur and Company. He advises listed and non-listed companies and also market intermediaries on SEBI laws, other corporate laws, and specializes in non-banking financial companies as well, structuring, implementing mergers and takeovers, buybacks, ESOPs, etc. Welcome, Mr. Thakur.
Good evening, friends. Thank you, Devashish. I think my colleague and earlier speaker has already given a groundwork of the company's bill and where it stands. Just one or two introductory points of the status of the bill and the SEBI ordinance, as I call it, the Securities Amendment Laws Ordinance, which has come and made a few changes. Some of them are very interesting or serious. The company's bill, which has got more than 400 sections, that will be the focus. Just one introductory point I want to say is that, as you know, it is still a bill right now, but the President assent which is expected, I don't think that should be an issue. My only just two concerns about the timing of when this bill will come into effect are two. One is now the Act has given a lot of things to be done through the rules. And though I keep hearing that the rules are fairly in an advanced stage, or maybe the draft ones are already approved, that is something which are also have to come, and we'll have to see those rules in line of the Act and see how they also affect. And when those rules are also ready and notified, or capable of notification, really this law will come into effect. The other point I want to make is that in recent times, last 8, 10, 15 years, if you have seen, most of these laws relating to corporates have a provision that they will come into effect partly or wholly on notification. So it may happen that the whole Act may not come on notification right from day one. Like if you go back about 11 years, Companies Amendment Act 2002 is still not effective as of today, because there are certain provisions which have come into effect, certain provisions have not come into effect. Some of this was because of litigation, and sometimes maybe the lawmakers realize that there are some problems in the way the laws have been framed, so maybe just let them just fade away. So here also there are so many independent sections or group of sections in this Act. So like for example, class action, they are capable of coming into effect independently of the remaining. It will not happen that it does not matter that if they don't come into effect, that other provisions will get affected. So for example, class actions, if it doesn't come into effect, still the remaining of the law will not get affected. So it is possible that some of these chapters or groups may come into force over a phased basis. So we'll have to see how it is. But the problem with when you make a Act passed by Parliament is that you won't be able to make a change, because the Lok Sabha has passed, Rajya Sabha has passed, President's assent has come. So you'll have to come with the amending Act if you find any problems. That was one point. Another point, just in lighter vein, the way I've been reading the latest Companies Bill 2012, we have seen so many versions. Many of the new provisions, in the sense that what was not there in the earlier 2009 version, 11 version, and even earlier, are there because of two major recent experiences, or maybe embarrassment, whatever you call it. One is Satyam and one is Sahara. In both these cases, so many of the provisions relating to the Companies Act came into questions, and the amounts involved were in thousands of crores. And certain provisions, independent directors and boards' powers, and so many, whether, how the shareholders could compensate themselves for the losses. Like, what happened in Satyam's case, you would have seen that in USA, they nearly recovered 1,000 crores in just two class action suits. And the third class action suit failed because of certain reasons. But in two class action suits, from the company and from the auditors, they got nearly 1,000 crores or nearly $200 million. So, in India, that did not happen. So we have now a chapter on class action. Then we have so many other provisions. So the stamp of, the visibility of Satyam and Sahara is there so much, Subrata Roy and, Ramalinga Ramji, these are two phases of these two companies. And, so I was just thinking that abroad in USA particularly, almost every law has got some inspiring, the persons who inspired them. Their names are there in the Act, like Sarbanes-Oxley Act or Dodd-Frank Act. So I wonder whether we should call this Act as, Raju and Roy Act. The approach which I have done is that there are so many provisions in this law. I have tried to focus on 4 or 5, as Savitri explained, that we'll focus on 4 or 5 major areas. And then there will be, if time permitting, there is a miscellaneous section which, I'll try to deal with. Otherwise, we'll deal with specific questions, because, this is a huge law. Even the Companies Bill, it's 400 sections and so many subsections and so on. And most of them are quite new, or small words inserted here and there have their effects. What I have tried to concentrate on are 4 things. One is that what are the problems, what are the certain problems which are being faced. Then what the law has tried to do is, make some prevention for that. Mainly, what I'm dealing is 2 gatekeeping, factors, both of which are already there, but now they have been enhanced. One is independent directors and auditors. These are the 2 gatekeepers to stop certain things on behalf of the minority shareholders or in, the society in general. So these 2 things, what are the changes I'll try to see. If these gatekeepers, they do their act, still the companies do some wrong, or these gatekeepers themselves do certain things wrong, what are the consequences? So there are certain very harsh and very new punitive actions which are there. Now, all of you will agree that, the fact that, Raju is in jail does not help a Satyam investor get back his money. If his 100 rupees has become a fraction of his, original investment, the fact that, somebody is in jail, because of his alleged fraud does satisfy a little, but it does not put him back where he was. So, we have certain remedies. One of them is, class actions, which I'll try to go in some detail. And we have certain new punitive and remedial bodies. What has been found that MCA by itself or SEBI by itself cannot, effectively and on a fast track basis do certain things. So there are 3 or 4 new bodies. And, this is where we, investors would have to approach, or, whoever is concerned who is affected could approach, and even the government could use them to punish or to remedy or to compensate the shareholders or the culprits. Independent directors is something which we already know, and SEBI's clause 49 is said since more than a decade now, and we know who are independent directors. There is no point in going through. Broadly stated, independent means independent of the company and independent of the promoters. So you should not be having such sort of relations with the company or the promoters that you become, biased towards them. It's like if I'm having a give and take relationship with them, mainly taking relation, then I won't be able to be independently judge what are the things which are happening in the company. So that is, I don't want to go into more details. We have clause 49 and, the new provisions which are there in the Companies Act are broadly on those lines, that how is independence defined. We have, clause 49 of the, listing agreement which SEBI has introduced, giving a certain ratio of independent directors out of the total board. So it is 1/3 or 1/2, depending on certain situations. The Companies Bill also wants independent directors provisions, and, they want that it should be 1/3. Although the corporate governance new provisions are there more since a decade, there has been a general cry or, complaint that what is this concept of independent director, and most important is this particular, the way it has been structured, the way it has been copied from the US model, is it relevant here? We have this Cadbury's report, the stamp which is being given. But there is a fundamental difference, and, many research scholars, many journalists, even our, minister at that time had raised the question that this particular concept of independent director and the way it is implemented is, just copied from USA, but this, the facts are different there, and what we have facts are different here. And there is one basic difference which is there. If you could Google, there is one, original report by 2001 by one research scholar under a study sponsored by Oxford University, Jairus Banaji and Gautam Modi. These 2 people have done an excellent study. I had a fortune to talk with them, and they have talked with so many people in the industry, profession, so on. And what they said, and what some other people had also said, but they put it in a very systematic manner, and they said that in USA, for example, the holding, there is no promoters concept. We have Birlas, we have Ambanis, we have Jindals. Most of the companies in India, Infosys, HDFC, these are rare exceptions. In India, we have got promoters concept. There is usually a family, Ambani, Birla, etc. Even the small company, medium size, large size, they have this concept of promoters, and they typically, there have been studies for that they typically hold, 48%. That was a 2010 study. That 48% of the company's holdings are held on an average by such promoters. There it is in single digits, and they don't have the concept of promoters as widely there. And there the corresponding figure was 8%. So we have 8% holding there, and the 92% is held by the public, maybe diffused, maybe in the hands of institutional investors, and these are the people who are really electing the directors, including the independent directors. So independent directors are directly selected by these so-called public shareholders, or they don't have really this concept of minority shareholders in the way which is there in India. In India, typically the shareholders they are less than 50%. Now that to elect a director, you need 50% plus one vote. Now, if the promoters are already holding 50% plus one vote, they are the persons who are going to select the independent directors. So if they are the persons who, they may be independent, they may not be having any relations, but the key to appoint them is in the hands of the promoters. So the question always will be that whose interest they will serve. They are the persons who are going to decide their remuneration, they are the persons who will decide their appointment, their removal, and so on. So this was, if you read the Jairis Banaji's, that is one report, you could see many other reports that are very, very detailed. I have been tracing those reports, and one, in 2011 by Dr. Umakant, and he has made, his report now contains another 100 references. That there are 100 other reports which have also said something similar. That, this transplantation effect has not been considered. So whatever we see later on, for example, we have got audit committee. It is consisting of so-called independent directors. But again, all these people are appointed by the promoters. So, effectively by the promoters. Because, in the shareholders meeting, the persons voting will be, it's not that there is no concept of majority of minority. That, 48%, out of the 48%, some people will select. It is, going to be an overall shareholding, and naturally the promoters would be, will be able to decide the decision. This I'll be repeating again and again, this particular anomaly, to decide that whether independent directors, how much could be the impact. Now, this is not to derogate any of the independent directors. Many of them would be doing good work. But to say that, they are really the minority director shareholders representative is fundamentally not correct. Then there is another, question, that why do we want under the companies bill yet another, set of provisions relating to corporate governance, independent directors, audit committee, ex-committee, when there is already clause 49. So there is a, level of duplication, there is a level of overlap, there could be a level of contradiction, and it's, whether this is one-upmanship, and, it will create to some level complications. The only difference I could find is that, what could happen if these provisions are violated. Clause 49 is part of the listing agreement. If that is violated, the company would be held liable for a penalty up to 25 crores rupees. So that is a civil liability. You could call it a criminal liability because it's a penalty. In case of the company's bill, what has been provided is not only a penalty, but even imprisonment. So if you violate the provisions relating to, for example, stakeholders committee or nomination committee, or maybe even audit committee, the consequences, and all the provisions. So if I'm just being a little bit extreme, but suppose if the somebody from the audit committee is required to come to the meeting and it does not come, or somewhere it does not smallest, all of these have as one of the punitive consequences imprisonment. So this is something which is going to be, the back of the mind of the independent directors, of the other directors, that, what will happen if something, somewhere something small or big goes wrong. If you do a fraud, then you have to face everything. But if some technical violation still, do you potentially place imprisonment? That is one of the consequences of putting it into the Companies Act. Talking of majority and minority, the manner of appointment, I was saying that, in a general meeting where these directors will be appointed. Now, the independent directors are being given a term of 5 years at a time. So you appoint them, they will be there for 5 years. So there is, they have this fear gone that, in the next, meeting or somewhere else, they will be just removed. So there is a 5-year term assured, and there is another term which they are assured. After that, there is a cooling period. But again, in the appointment method, I see this contrast. If a lender is there, then he has often got a right of nomination. So if you lend a certain amount, the company will agree to you that you can put a nominee. Now the shareholders are holding up to 50%. They don't have a right to put their nominee. So this is again, I find a little inequitable. If you see shareholders agreement, you see this, Etihad, Jet Etihad, and so many other agreements. Most of them have certain clause that those small minority investors have got certain rights, including putting their own nominee. But the diffused minority do not have a director which is exclusively appointed by them. In fact, we have this concept of small shareholders directors. That particular provision is still there in the companies will also carry it forward. But it is optional. Up to 20,000 of nominal value of the shares, a director representing them could be appointed. As far as I know, not a single company has used this particular method and put a small shareholder on their board. Now, if such a simple thing of, putting somebody, you put it open, let somebody come. If nobody comes, it's fine. But if somebody wants to come, allow him to them, hold a separate meeting, let the small shareholders elect their own director, and at least there is some satisfaction that, at least for a small section, there is somebody there on the board. Now, in fact, I was reading that 2 or 3 cases which I have read, in all those cases when somebody tried, those people were outvoted. That whole proposal was outvoted. I don't know the details how they got outvoted. But as far as I know, I'm open to correction, but as far as I know, not a single company of these thousands of listed companies have put a small shareholder director on their board. There is a detailed code for independent directors put down, what are the do's and don'ts for them. Interestingly, there is no similar code on the company or rights for the independent directors. So they have a lot of obligations, a lot of liabilities, you will not do this, you will not do this, and so on, or you'd rather do this particular way as an independent director. Have a right, specific, section saying that, okay, these are your rights against the company. These are the things you can do. These are the things you can, ask from the company, or, and so on. To some extent, certain committees have got some rights. For example, the audit committee has got certain rights to use the resources of the company to ensure that, for example, they can take opinions and so on. To see that, if they are not experts in certain fields, they can get knowledge and, expertise and get their things done. Then comes one point is that, remuneration of independent directors. And, this is what was referred to earlier also, that, what should be the independent directors paid? Now, one thing again I want to remind you is that this will generally be decided by the promoters. That apart, if you want an independent director, today, for example, the sitting fees are up to 20,000 rupees. So, this is what could be paid. In addition, a compensation could be paid, plus a profit-related commission could be paid, plus stock options can also be paid. These are the 4, at least these 4 different methods. And of course, the expenses which are incurred for coming, going, and, related, reimbursement of expenses also there. But there are various ways of compensating them. And this is where the risk is that, if you underpay, then they don't have motivation to spend their time and, efforts to study the company and, study the matters which are going on. And if you overpay them, since the company is paying, and since the promoters or the management would have a say in deciding that, then they might lose their independence. And particularly if I am suppose earning 10 lakhs rupees a year and one company gives me 6 lakhs of of fees, then my 60% of my income is from those people. So whether I will be able to maintain my independence. What has happened now is that this remuneration concept, they have diluted it substantially. What they have provided is, now, the wording, I am not going to the legalities. It could be interpreted, there is a small chance to interpret the different way, because I've been asking people and some of people said, maybe let's wait for the rules also, but I don't think that is the case. You can be paid only sitting fees. I don't know whether this 20,000 is going to be revised, but otherwise there will be 20,000 into 4 or 5 meetings, 1 lakh rupees a year, this is what they will get. Let's ignore the expenses, no remuneration can be paid. Only profit-based commission can be paid. No stock options. Stock options are specifically prohibited now to be paid. So what will happen is that typically a independent director will get sitting fees and a profit-related commission. If there is profit. If your profit is 0, then there is negative, then there is nothing you will get on that account. So now that also the profit-related commission for all the independent directors put together, the maximum amount totally can be given is 1% of the net profits. Now, this is where there is a managing director, which is always our whole-time director, which is usually the case. If there is no managing director, whole-time director, then it is 3%. But typically, the maximum amount, totally all the directors, in fact, not just independent directors, even all the non-executive directors put together will get 1% of the net profits maximum that is permissible. Now, just again in the lighter vein, I was, comparing various percentages. Maximum amount, all the independent directors and non-executive directors put together is 1% they can be paid. Compare this corporate social responsibility. The company, the amount which they are required to spend on corporate social responsibility is 3% of the net profits. They are now allowed to give charity funds donations. That is 5% of the net profits. And interestingly, political parties are now allowed to be paid 7.5% of the net profits. It was earlier 5%. And now it is 7.5%. So imagine the priorities of the lawmakers. To the independent directors who are really they should represent the minority shareholders, they are going to get maximum 1%. Political parties will get 7.5% of the net profits. And I don't know whether it is really the business of a company to pay political parties, but maybe in a democracy, if you are participating in the infrastructure, maybe some of your profits should go into the maintenance of democracy. But that is saying it, putting it very nicely. I discussed, a small shareholder director, and I already, nomination and remuneration, these two committees are there, which I think to some extent, Savitri has already discussed. Audit committee has, is in parallel with, what is there in the clause 49 with a few changes here and there. Nothing really worth to spend time on. Consequences of violences I wanted to highlight again is that surprisingly, if something is not made, some mistake is made in the managing of the, this committee, right from something which is seriously made wrong to small administrative details, all of them have potential penalty as well as imprisonment. So again, this is something which I find strange that, and this is, just a trailer, I'll be showing you something more serious later on. More powers are given to the board in the sense that, certain things, there used to be a list. There is a list of things which should be approved by the board and not by the managing director or whole-time director. So certain things, certain decisions can be taken only at board meetings. That list has been increased now and many other things have been added. So in a way, the independent director's responsibility has increased, and I'll be discussing, that how it has increased. I'll show later on. So these are the people who will have to look at more things mandatorily. There are so many things which come routinely, or the company puts them voluntarily. But there are certain things which is now an increased list, which will come to the board, and all the directors, including the independent directors, will have to spend their time on. There are certain things now which are, which are again already there before, in the Companies Act 56. Now that list has been modified, or certain things have been added, or substantially modified. Those things now have to be approved by the shareholders. So in a way, there is relief that okay, these particular things, they are a little sensitive. Put it before the shareholders. Let them decide. And whatever they decide could be final. Now what happens if independent directors, something goes wrong in the company? What are the consequences on the independent directors? Now this is again, you must have seen, Satyam again, as I said, Satyam is like somehow at the back of the mind of the lawmakers, or at least I see from the wordings of the law, that some certain things happen in, some of the best, best of, people, most reputed Harvard professors and so on, they were there on the board, and certain things, over the years, some $1 million of, funds were allegedly, kept in things and they were not existing. So if these type of things happen, what is the responsibility of the independent director? What has happened is that they are now, as they were there earlier also, but now they are part of the officer in default. Officer in default is that particular legal concept where if something goes wrong in the company is made liable, and the officers who have defaulted, they are made liable, and they are defined. Now what has happened is that, directors all will be, of course, made responsible, but for an independent director, an exemption has been given. So that is good and maybe bad also. I'll explain which are the situations under which they will be exempt, and that is very interesting. What has been said is that if a board meeting has taken place, they will be liable only if that particular matter was passed by the board, and the member, the board member came to know, through the board process that this has happened, or he has received minutes. So suppose, there is a board meeting in which a particular decision was taken, and, he participated in that, or he was even present. So that is where he'll be held liable. So it's, if, for example, managing director does some fraud, or if, some lower level person does some fraud, that matter does not come to the board, then he will not be liable. If he does not attend that meeting, and he receives the minutes, which is very quite standard practice, that the minutes of the earlier meeting either are, not only they are discussed in the next meeting, but there are a copy of that, Savitri will agree, is given to all the directors, so they know what had happened in the last meeting. Even that will be deemed to be knowledge and of the particularly if that suppose a certain act had taken place, again Satyam's case, when they tried to acquire Metas and through the board meeting and so on. So if that had happened, and if he was not there and received the minutes, still he would be prima facie liable. These are the two conditions. So in a way, his responsibility to attend and look at the board meetings is increased. At the same time, if it did not happen at the board meeting, then he would not be. The other thing is where this is done with his consent and connivance. So suppose he participated in certain things here and there, or rather he was an active part of the whole fraud. That is a different thing. But otherwise, something which has happened in the board. Now see, this is easier said than done. How, if you say that, only things which come to the board of directors, those only will be liable, it's a bit misleading. Because if you see typical board of, meetings, papers, I typically see, one or two places where I'm director, I see typical how the company secretaries and, the management send, they are inches thick. File is sent, so many things, details are sent. Now, I don't know how many directors really go through comma, full stop and all that. But if it is shown that in that, there was one particular paragraph dealing with one particular decision, and that decision wrong, or it was fraudulent or whatever, then this particular exception won't be available to them. So this is dual-edged sword which independent director will have to deal with. Class action which is there, which I'll be dealing in detail, and fraud. These are two new provisions which I'll be dealing with, which is again independent director will have to face them, and possible certain very serious consequences. Let me deal with one particular thing, related party. Again, Satyam, Metas, it was a related party transaction. There was a group company which they wanted to acquire, the business which they want to acquire, and it was a related party. So what are the provisions? So now there is a particular section, the clause in the Companies Bill itself, which is going to be dealing with related party transactions. It means, it is a typical thing that if in a public company, if I, involve my, let's say, nephew, and, give him some business, naturally, if I am the person who is going to deal with that, I am not going to be biased. I am not going to be independent. I am going to be biased. So naturally, related party transaction has to be dealt specially in such a way that there is no loss to the company. Now today there are many provisions dealing with them. There is already clause 49 audit committee, to them these transactions are placed. There are certain provisions under the Companies Act which on a specific basis deal with related party transaction, but now we have a section which defines what is a related party transaction, and in case of a related party transaction, it says that it defines related party transaction, and what is the procedure for dealing with related party transaction. The most logical according to me is that if the related party transaction, remove that related party and the person related to them, let the remaining people deal with this transaction, let them decide, in the absence or without being affected by them. So the related party, the concept has been very widely defined, and just to give so many examples, apart from the typical that one of the brothers may be appointed as a managing director, or one of the relatives, a company is appointed for doing business, or as a sole selling agent, or some other business is being given. Those transactions will be related party transactions. On a more serious level, we have parent companies are being paid royalty. Multinational companies, they pay, the local companies pay their parent companies royalty. They purchase goods from them, they sell goods from them. We have a whole, you would be knowing a transfer pricing cell and set of transfer pricing provisions under the Income Tax Act dealing with this to ensure that, the profit which belongs to the company on a fair basis comes to the company. So this concept is something similar. So related party has been defined very broadly. Related party transaction has also been defined very broadly. And if those things come, then there are two things which are required to be done. One is that that particular matter has to be decided by the board. So if these transactions are, the board of directors has to decide and give an approval. At the board level, there is no exception made for the related party, but generally, looking at other provisions, the directors who are interested normally will have to avoid, participating or voting on the particular transaction. The bill also provides that in case of certain large size companies, this particular transaction will also have to go to the general body. A special resolution will have to be passed, and the related party in the company, the particular shareholder who is also related party, he will not vote. So there will be a special resolution of the non-related party shareholders. So that is very, very fair. So in a broader sense, so, and this is something interesting. We'll have to see that so many, particularly royalty to the parent company, multinational company, and purchases and sales, and those are always questioned in newspapers and elsewhere and by institutional investors and activists. That is the amount going out from the company too large in comparison to the amounts, the value which it is getting. So those all things will now come before the shareholders, because, I believe the threshold, which is going to be prescribed of the paid up capital beyond which, the general meeting will have to decide could be, not very large. But, again, there is, there is a big fat loophole which is there, or, exception which is there. And, it looks very, innocuous, but it says that if this is not required, none of these precautions or none of these procedures are required to be made if that particular transaction is in the ordinary course of business and at arm's length. Now, if it is at arm's length, then the matter need not even go to the board. It need not even go, to the shareholders, and it will be decided naturally, at the management level if they are authorized to do that. Now, my question is that who decides this arm's length business? Isn't, if I am doing a transaction with a related party, should not the persons other than the related party decide that whether it is at arm's length or not? See, first of all, this concept of arm's length also has got so many subjectivity. If people who are familiar with tax and transfer pricing know that there are so many methods to determine whether it is a fair price or not. Now, if that itself is a subjective thing, how do you let the person, who is going to be affected and, decide whether it is arm's length? Now, of course, he will be answerable. Tomorrow, after 2 years and 3 years, and suddenly somebody finds that this was not an arm's length, and, but the point is that why there should be any exception given? Why not at least at the board level? And that also, I'm not comfortable that the whole board should decide, all the related parties should be put aside, and not through indirect provisions, direct provisions. But this is a concern which is there. I'm finding this exception too wide. And if you can go through any annual report, at least I was seeing various annual reports, in relation, they have got a standard paragraph. They will give a big list of related party transactions, and they said that none of these transactions, all of these transactions are at arm's length, and none of them affect the corporate in any significant way. Now, this is one thing, who has decided, who has checked it? If you're doing first of all, why do you do a related party transaction? Why do you employ your nephew and so on? Or whatever, you may be doing. And now there may be genuine reason, like, Gillette company, which is there, abroad, Gillette India, Gillette India may not be able to function without the patents and, by various technology which has got. So certain things are unavoidable, but why not put it totally beyond that bias which is potentially there? Auditors, my profession, although I don't do audits, they have been, to some extent rightly and perhaps to some extent wrongly, been, maligned. And there are certain, first of all, they have rightfully complained that, we don't get that independence. Every year our appointment is put before the board and, the shareholders, and we could not be appointed. So like independent directors, now they will be given a short terms up to 10 years. After that, there will be a cooling period. And, at every 5-year term, there will be there is a regular ratification also. So 5 years, 10 years, a short term will be there, and after that, you please go out so that some new person can come. So you get your independence. At the same time, you don't get too attached. That is one thing which is given to help them. The other thing which has been taken away, that but the prohibited services. If I as an auditor, I get certain fees, but company says, okay, now why don't you do this particular business and give me this services. So by that, my independence would get affected. So that list of prohibited services, internal audit and X and Y and Z, corporate management and so on, those lists have been increased, and those things cannot be rendered by not only that particular firm, but even a firm which is having the brand name of that, just to take Pricewaterhouse is the auditor, and Pricewaterhouse Private Limited is a consulting firm. Pricewaterhouse Consulting, but is using the same brand, it won't be able to give these services also. A new provision which has been made is that auditor will act as a whistleblower. So if there is a fraud, it finds during the course of business, there is a fraud, something, some people are carrying out some fraud, it will directly report to the central government. And normally the auditors, being chartered accountants, they are not allowed to reveal confidential information relating to the company, and there are certain ethical issues. Those provisions the Act says that those will not apply. This particular requirement override, and this particular auditor as whistleblower, that issue has been also given to company secretaries in case of secretarial audit, and cost accountant in case of cost audit. So all these three people will also act as whistleblowers and inform the central government if there is a fraud which they believe which is going on. Auditors continue to be appointed by, effectively I would say by the promoters, because if you are holding more than 50%, you are, so whether that, like the independent directors issue, whether this particular thing should be addressed, I think, this is an issue which should be thought about. Unfortunately, the bill does not make any difference about this. CAG, Comptroller and Auditor General, government companies are there. There is a separate, body which appoints from a panel of auditors. So the management or the government does not decide. There is independent. So this is just a thought. Many times, the private equity investors which are there, they invest. They say that, okay, we'll have a say. Who will be the auditors? Whether if the auditor is changed, you will take our permission. Now, why not minority shareholders also? Phenomenally increased liabilities. They can be subjected to fine. If they do certain wrong things which are listed, they will have, they could be removed. The fees which they have been paid, they can be refunded. They will be required to be refunded. Penalties will be subjected to them, and compensation for the loss which has been caused. That is what they will have to make. Class action, these are, interestingly, class action is not just against the company or the directors. It will also be against the auditors. We'll see that a little later. Fraud and prosecution, they can be put to jail. They are one of the people specifically named, along with many other people who can, this is again I'll deal with later on. And, the auditor who has signed and the firm, both these two people will be liable, not just the auditor or not just the firm, but not the other partners. So the firm's resources will get sucked into, the auditor's personal assets will get sucked into. Other partners, if they are not involved in the particular, wrongdoing, they will escape. But just keep that in mind. Nowadays, auditors can have a LLP, limited liability partnership. So what are the resources that should be there in the firm which can be used? Even otherwise, I don't think auditors have deep pockets. Although my jacket may be having a long pocket, I don't think auditors are somebody who have that high assets. Although in Satyam's case, they paid a very hefty amount. But we are talking of a global organization. I want to really highlight this particular chapter, or rather there is one particular provision, clause 447. It is put under a chapter called miscellaneous. So, typically, even people readers, miscellaneous chapter is there, just skip. But if you see the first clause there, it talks of some very serious things. It talks of basically fraud. And it says that if a person commits a fraud, the company, the directors, the officers, the auditors, the experts, the valuers, the advisors, if any of them commit a fraud, and this is for the first time I'm seeing it probably in any law, not even under the Indian Penal Code, except the only thing I remember is in two cases. One is the anti-rape new law which has come, and another is the NBFC case. Except this, I have not found such a provision that there is minimum imprisonment of provision. See, if you commit even a murder, there is no minimum imprisonment. There is up to 7 years, up to 14 years, up to X years. If you break somebody's bones, up to certain years. Only this new anti-rape, law which has come, which is probably a really serious reaction to the Delhi rape. It talks of some minimum 3 years and 7 years and so on. But this particular, under the Companies Act, if you commit a fraud, you go for a minimum imprisonment. All these people, auditors, directors, officers, all these people who are found to have done the wrongdoing, would go minimum 6 months into prison, up to 10 years. And if the public interest is affected in that particular fraud, I'll not go into the technicalities of public interest, but just tell you that if public interest is involved, then the minimum imprisonment is 3 years. So from minimum 3 years up to 10 years, this is the imprisonment you face. Now, fraud is very widely defined. If you make a misstatement, I'll be giving some examples later on, but apart from the very obvious frauds, like, for example, if you have made a total 1 billion, if there is a hole in the balance sheet, that is of course covered. But if you make up 600 rupees, 500 rupees excess, you make your travel voucher and put 500 rupees extra, that is also the fraud. So, in my Gujarat, there's a saying that tak ser baji, tak ser khaja. There is one particular standard, a minimum 6 months imprisonment for all types of frauds, all types of misstatements. Minimum 6 months, maximum 10 years. Of course, between 6 months and 10 years, the judge sitting there will decide. But if the matter comes before the court, and if the person is found guilty, then a 500 rupees, technically a 500 rupees travel voucher would also face 6 months minimum 6 months imprisonment. And this is not or. This is not or with fine. Typically, most provisions which are there in the Companies Act, I believe almost all of them, if I could be corrected, but all the provisions say imprisonment or fine. So, in some cases, the person could be paid fine of 100 rupees, or depending upon the seriousness, something far higher. This is only the provision, which is there, which says and fine, and therefore there is no compounding. You cannot compound any of these offenses. There is a big list of, apart from this, what I have said, there is a big list. It's worth reading. All these things, even if you make multiple application shares, this Rupal Ben Panchan's case, I think that was the back of the mind probably. That is fraud and you go to prison. Directors and officers and auditors insurance policy may help some of these people to meet the losses. Let me now quickly deal with class actions, which was, that I discussed earlier. And referred to, and this is where the minority shareholders can directly take action and get their money back. Then it's a very sensible provision. What is said is that if the company, or if the officer, if the auditor, if the expert, if the valuer, and so on, if they do a fraudulent action, if they do unlawful action, if they do wrongful, and if there are various conditions, various criteria put on, but unlawful, fraudulent, wrongful should tell you what it is about. If they do certain, even illegal and ultra-vires acts, if they do these type of things, then the persons who are affected can go to the NCLT and say that, the persons who are responsible, you pay the loss to us. So for that, not any small shareholder, can just file a NCLT. What, a gatekeeping concept is that minimum 100 shareholders, or a percentage of the share capital as may be prescribed. So I am just guessing that that could be 10% if I look at other provisions of today. So 100 shareholders or maybe 10%, whichever is lower. So if 100 shareholders get together, they sign a piece of paper and appoint a lead representative, those people can go to NCLT, say that this loss has taken place, and the NCLT will be required to make those persons responsible, including the company officers, independent directors if they are held liable because of the involvement and so on. Any of these auditors, valuers and experts and maybe lawyers, company secretaries, any persons who are found guilty. And the loss can be even to the creditors, but really the shareholders or also the depositors. There are two people who are allowed to file a class action. One of the good questions which was raised is that this is litigation is a very expensive affair. Who will finance this? Small shareholders don't have money. So one is that first of all the lead representative will be appointed, and maybe these people shareholders could go together and put some money inside. The idea will be that to of course distribute the cost proportionately after this matter ends. But 100 shareholders put together. So first line of action will be by the shareholders. In USA, from this where this concept has come, lawyers can finance. Because lawyers are allowed to take fees on a contingency basis. So in fact, not only they finance the cost, they even pay to the shareholders. Okay, keep this money till this, but you give me the right to fight this suit. So they, then they get a percentage of the outcome. Today in India, this is not allowed. No lawyer, CAs and CSs are also allowed to appear before the NCLT, but they are also bound by their ethical code. None of these three people can take a fee on a contingency basis. So I really doubt lawyers can, beyond a little bit leeway that, okay, you pay me later on, but they cannot, finance that particular litigation. If assuming that they have got deep pockets. Third-party litigation funds, they have already shown, particularly foreign funds, they have shown a lot of interest that we will finance, but we will take a percentage of the outcome. So if the outcome is zero, then we, let our money go. So these people are, if they are allowed to come, there is a legal one particular problem that in India, there is a concept called champerty and maintenance. In the sense that, particularly lawyers would know that involving oneself in somebody else's litigation, whether for a share or whether not for a share, is against public policy, and that particular contract is held to be void. There are certain exceptions, but this is a basic and principal rule. So, the persons who are funding, they face the risk that, after, the shareholders got the money, they'll say, okay, this is the contract is void, and you take a walk. Insurance policies, insurance companies could be another line of, those people may finally have to, pay this. So that is, insurance policy is one thing. Company and the defaulters, if NCLT orders, so if NCLT at some stage orders that this is a bad situation, then they will order the cost to be paid. SEBI has put actually in 2009 they have set their own regulations, investor protection fund regulation, and one of the purposes of this fund is to finance litigation in case of small shareholders. There of course the benchmark is a little higher, but that is one of the sources. I'm not so hopeful about that. But these are the hurdles which, because this is a US concept introduced in India where this concept was never there in this particular way. While there it is in a wide way, even consumer torts and all that. If you should read John Grisham's novels. He has made a career on writing novels on class actions. Mike, one just last question. I think I'm exceeding my time. So, but my question is that why should small shareholders go for violations of the company of fraud, illegalities, those type of things? See, I can understand that in the Yes Bank matter, it is a private matter really. The legal ads of one particular brother and the other brother, they had an agreement, and they are taking action and they are fighting on themselves that SEBI and RBI, and they are really not directly concerned that okay, we'll solve this problem and make that person pay. Here, if a fraud takes place, if a illegality takes place, if a wrongful takes place, SEBI has got first of all a lot of powers. It has got resources. It has got money. Why not? SEBI or MCA should do this. In fact, recently, if you see, disgorgement powers have now officially come under the ordinance. So why not SEBI should? In fact, there is a case of VCL, Vital Communications Limited, you could read up, said, in this one particular shareholder and said that I have suffered a loss, make SEBI ask the company to do it. So basically, SEBI said, I cannot do that. SAT also said that basically this should not be done, but SAT made a very interesting observation, Securities Appellate Tribunal, that if the SEBI finds that the fraud has taken place, then it could direct the company to pay this particular shareholder his money lost plus interest. So my question is that why you are making the small shareholders suffer run here and there when you are a body which is already there. There are new enforcement bodies, serious fraud investigation officers. In a way, it is already there. Special courts, NAFRA, adjudication officers. These are the people now dealing with penalties, prosecutions, and so on. And these all will help. Special courts will be a fast-track way of prosecution. SEBI ordinance also deals with that. Just this last point before I close is, in the SEBI ordinance, there are so many small things to discuss, but I have just this one point of worry. Today, if a person does not pay the disgorgement amount, or he does not pay the certain penalties due from him, SEBI did not apparently have a lot of powers, so this ordinance gives them powers to attach the assets and recover in a fast track manner the amounts due. But what I found disturbing, now this is fine, what I found disturbing is that SEBI can arrest a person and put him in jail for not paying the amounts due, not only the the amount suppose he has done by fraud, but even let's say the fees which is due to SEBI. Even if he does not pay the fees, he can be jailed. Now this is I find it throwback to 500 years because of where there are debtors' prisons. If you read Shakespeare's books, there are debtors' prisons which are referred there. And and this is what a mafia does. Mafia authority does that. If you don't pay my money, I'll kidnap you and put you till your family pays me. Why should SEBI take this step? See, these are all very dangerous things. There are many other things, even in this, search and seizure. This time does not pay. One should read that, search and seizure, no magistrate's permission is needed. SEBI's chairman signs and search and seizure can be made. Now, there are situations which may require, but what is the protection mechanism? With that, there are so many other things which are there. It's a huge bill, but somewhere we have to stop. It's not that companies are not innocent. They have so many things which they could have avoided doing, and still they did. Something they could have voluntarily done, something they could have avoided doing. They kept on doing, and now we have certain law which I would call it a police act or even a mini TADA. There is a provision for non-bailable offences. Many of these things are non-bailable also. There is no, no arrest warrant is also required for SF5 and so on. These are things which need consideration. I don't know whether this law in certain aspect has been fast-tracked too much just to get act in place. And let's see how these things go, whether, the companies will run away or they will be held accountable. Thank you.